Hello, welcome to today's immigration tidbit. All right, first of all, private citizens cannot deport anybody. Okay, they have zero power to deport somebody. Okay, that is in the ambit of federal law, and it is the designated agents under the specific agency in immigration that determines whether or not someone's removable. There's different entities in the administrative arena that can issue a notice to appear, but the notice to appear is the initiation of the removal process. It then ultimately goes to the immigration judge, who then decides whether or not to issue a removal order, and then it goes from there. Uh, Governor Greg Abbott found out the hard way that even a state cannot usurp the rights of federal immigration law. As I'm sure most of you heard, he tried to put those buoys in the river, which ultimately ended up killing some people, and it interfered with federal U.S. immigration law. So, very particular exactly who has the jurisdiction in which to do that. Now, if your question is, can you do something to notify immigration of various violations to determine if they will seek to go forward with a removal, then that is possible. Okay. So, for example, let's say you happen to know a business that has 35 employees and 32 of them are illegal, and you happen to know that. The question, of course, is how do you know that? But assuming that you actually know that, it would be a matter of preparing the proper documentation to show, number one, who it is that is not here legally, how you know they are not here legally, you got that information properly, and various other factors which determine whether one is removable or not. That particular packet, that information packet, would then go to the proper immigration official, who would then decide whether or not to proceed with initiating the notice to appear in order to go forward with removal proceedings. It is not simply something where you see a company and it's got a bunch of employees and you think they are not legal and you think you are going to do something about it. It is not where somebody at some company rubbed you the wrong way and you're going to try to get back at them by doing this. It's not a retaliatory type measure. It needs to just be presented in a matter of fact and a legal matter of fact how you came upon the information in order to go forward. Now, just so you know, just because somebody is working here illegally, they may be removable, but they may be able to fight the removability in order to stay here. I've represented plenty of people in removal proceedings who were not here legally, who under the law, under the items afforded to them by the law, they won various immigration relief battles and were awarded residency. Some weren't awarded residency, but some were awarded the ability to remain here without being deported. So there's a whole world of relief that is available to people who want to fight being deported. That's the law. Okay, if the law was anybody who's here illegally must be deported, period, and there was nothing else, we'd be having a different conversation. But in fact, that's not the case. There are multiple avenues of relief that one can get in order to either vacate, win, remove, or change a removal order. And of course, it's all laws that were, written by Congress, signed by the president, many years past, I'll be the first to admit there's a lot of immigration laws that are super harsh, that are very difficult to try to win, and that are very difficult to get removed. Uh, but on the other side of it, there are a lot on the other side of the aisle that give people a right to apply for various items. It's like what we were just talking about. What Abbott did, how he tried to usurp the federal immigration laws in his own use and use these big balls to keep people from coming over. Well, what was he really doing? He was preventing some people who had valid asylum claims from coming to the U.S. The law is very specific. If someone comes to the U.S. and they fall under one of 5 enumerated categories of asylum, they are eligible to apply for asylum. It doesn't mean they'll get it, doesn't mean they'll win. In fact, most of people who apply for asylum don't win. But he was preempting federal law by attempting to put those big balls in the river, which have then been ordered to be removed, of which he quietly had to remove. But there's a reason that federal law is needed in order to run immigration law, so that you don't have all these competing entities that try to usurp the power unlawfully of immigration law to try to avoid what the law allows. Again, if we're just going back to the asylum case, there's people who think that when someone comes here and they apply for asylum, they're going to be guaranteed to win, they're going to get the green card, and they're never going to leave. That's what some people think, but that's not the case, okay? The reality is that a decent, good, persuasive asylum application needs to be prepared. It needs to be argued. The immigration judge, if it gets to that point, needs to be convinced. The trial attorney needs to be convinced to hopefully not appeal if the win comes. There needs to be evidence, testimony. There needs to be all kinds of things that need to be presented. It's a full-blown trial that has to go forward. And last I reviewed, there was about 17% of people who applied for asylum win. Okay, that's not a huge percentage. That's about 80-some percent that lose. But then if they lose, they have the right to appeal. And if they lose the appeal, they have a right to do the petition for review, and so forth and so on. The law allows it. Otherwise, we would be a nation that, just looks at people, say, you're here illegally, get out. And that's not what we are. We give people opportunities to try to stay here as per the law allows. Okay.